Good evening, everyone. I'm making a video in respect to the factors that go into a lawyer's determination, particularly when the lawyer responds to the potential client indicating that the lawyer is not interested in the case, or the lawyer is unable to accept the retainer, or the lawyer simply does not respond to a person who contacted that lawyer asking the lawyer to assist him or her with a case. And while the lawyer may not provide reasons why he or she is declining the case, I will go through the top 10 reasons, at least the top 10 reasons why I may decline to assist a client in a case. And one of those reasons could be a potential conflict of interest. You may approach the lawyer to represent you in a case, but the lawyer has represented the other side or some witness or somebody who may have adverse information to give against you. And the lawyer may have had that information, be privy to that information. Or the lawyer may not even have been privy to any information. The lawyer may simply have represented someone from the other side. So out of an abundance of caution, the lawyer will simply not accept a retainer from a person who case may pose a conflict of interest, simply because the lawyer's loyalty is supposed to be 100% to that client. And if there's a conflict of interest, then it shatters that loyalty that should exist. A second reason is in some cases, the cost of the litigation is prohibitive. So a person may have a minor encounter, for example, with the police, or may have a minor encounter with someone else. And so they call the lawyer up, or they write the lawyer and say, I want to sue. And you say, well, how much do you want to sue for? And they're like, oh, I want to sue for 1 million. I want to sue for 2 million. Prepared to spend at least $300,000. You have to be prepared to spend a lot of money. Litigation is not a tea party, and litigation is quite expensive. And a civil litigation case right now can cost a client anywhere between $100,000 to $400,000. I mean, it all depends on how much that person is suing for, but there's certain truisms that come with litigation, and one of it is that you have to spend money to make money, and you can't show up and expect a lawyer to go into his or her pocket to fund your litigation. In some cases, the lawyer may do the case on a contingency fee basis, but in most cases, you got to pay to play, and sometimes the opposite side may even come after the client for security of costs. And that's what happened in a case called Chemical Vapor Metal Refining Inc. versus Terakov. And that's a recent decision reported at 2016 ONSC 6845. And one of my colleagues, Mr. Hodder, brought a motion for the other side to pay that security of costs in advance of the litigation. And the court agreed with him and ordered the other side to pay the security of costs in advance of the litigation. And it's quite interesting how the court dealt with that. So I'm going to use this case as a parameter for how costs can be charged. So for doing documentary disclosure and oral examinations, the court ordered $40,000 to be paid in 45 days. The second tranche of the litigation, which is preparation and attendance for mandatory mediation, the court said $13,000. The third tranche covering pretrial. So pretrial is when you go before the judge for an hour or so, or two, and you discuss the issues that will come up at trial and any prospect of resolution. The judge ordered $6,900 for that one-day appearance. And then the court ordered costs for preparation for and conduct of trial in the amount of $140,000 to be paid within 1 week of the completion of the pretrial. Right? So this is a person who wants to litigate and has to pay close to $200,000 for that privilege of litigating. Litigation is not right. They say where there's a right, there's a remedy. But, you know, litigation isn't necessarily a right. It's subject to you being able to pay the cost of litigation. And if the litigation is suspected to be frivolous and vexatious, then yeah, you got to pay that cost upfront, and that cost could be very prohibitive. So this was a good example of to show the cost of a civil action. Another good case is the Carmel, a case that my colleague Mr. Bogle did, and in that case, the person sued the police for quite a lot of money and lost the civil action. And what the court did there is slap the person with costs. And let's see how much cost in that case. The person had to pay the police $367,704.87. Partial indemnity costs is 60% of the cost that the other side would have endured or bore in terms of defending. So $367,704.87 that person had to pay. Now, if the lawyers didn't tell the person in advance that litigation is expensive and the person may be subject to that adverse cost, that person may well go after the lawyer saying, well, the lawyer didn't tell me that I could lose the case, and if I lose the case, I got to pay the other side costs. So more time, it's important that we tell you that. And I generally tell the client that. And that's why a lot of times now what I do is somebody may call me and say, oh, I want to consult with you on a particular case. And I say, okay, you're free to consult with me, but you have to pay a consultation fee. And my consultation fee is $650 per hour plus HST. And what that means is it tells me if the person can afford to pay that, it tells me that the person is serious. If the person already start crying, whining, and complaining that they can't afford that, $650, then I know the person can't afford litigation. Can't afford litigation. If you can't pay $650 to the lawyer for a consultation, that $650 goes into a trust account. But what it does is it signifies that you're serious and that you're able to not really squat on the lawyer's time or expect free service from the lawyer. Where else? I always wonder about this, and it bothers me. Which other profession is out there where people think they could just show up at that professional's office and get the person's time for free? Very few professions. In most professions, those people are being paid. And if a lawyer is self-employed, you're expected to pay that lawyer unless the lawyer agrees to do your case pro bono. There's nothing like a free lunch. The lawyer may do a case pro bono because it has significant impact beyond the person who brought the litigation, himself or herself. But it doesn't give you, somebody with your own personal issue and seeking compensation as well financially, the prerogative to show up to that lawyer's office seeking free legal advice. It's something that puzzles me. So people want to make money, but they want to make money free off of someone else's back. Well, you know what? Indentureship and slavery have long gone. So no, you want to make money, you want to seek financial compensation, you find a way to pay the lawyer or enter into a contingency fee arrangement with the lawyer. But don't think you can show up at a lawyer's office trying to make money for free off the lawyer's back. Another reason a lawyer may decline a case is that the case is not in the practice area of the lawyer. So a lot of us get approached to do cases in areas where, you know, yep, Richard Sturman wrote a lot of very good comments. A lot of lawyers do not dabble in areas for which they're not practicing frequently. So a criminal lawyer is not going to take a civil case. The criminal lawyer may refer the civil case to another lawyer. Do the criminal aspect, refer the criminal case to another lawyer. Right? That's a best practice approach. Or a civil lawyer should refer a criminal matter to a criminal lawyer. You shouldn't be dabbling in real estate or any other practice areas. Lawyers who dabble in practice areas for which they're not ably qualified runs the risk of having embarrassing incompetence of counsel claims or even law pro actions against them, or compensation fund, or even malpractice proceedings or law society disciplinary proceedings. So if a claim is not in a lawyer's area, they will tell you it's not in their area. They may refer you to another lawyer, or sometimes they may not. You know, they may simply say, call the Law Society of Upper Canada Lawyer Referral Service, and they'll refer you to a lawyer in that practice area. In some cases, the claim may appear on its face to be frivolous and vexatious, an abuse of process and a waste of public and private resources. I sometimes get those claims where people come to me saying they want to do A or B because they want to send the fear of God into another person. And I'm like, not on my time. My time is not infinite. And your money doesn't entitle you to use me in that manner. Because it's the lawyer's reputation on the line too, right? I mean, lawyers, even though there are 40,000 lawyers in Ontario, you'd be surprised how it's a small fraternity. You know, my friend, for example, Richard Sherman, who is online tonight, he practices criminal law. He practices very frequently in the courts and have a great reputation, right? But if Richard didn't have a great reputation, right, lawyers would say that, you know, that guy, stay away from him. He's a dump truck, or he's this, or he's that. He has no, you know, that's what people say about lawyers who have no integrity or play fast and loose with ethics. I'm not that type of lawyer, you know. I do not risk my integrity for anyone, right? At the end of the day, I have to be comfortable with all the decisions that I make. And your money that doesn't really go very far, if it's not money that will last me for a lifetime, do not allow me to take that risk to lose my license. So some cases that are a waste of public and private resources, you know, if a case is frivolous or vexatious, generally the court order costs on a substantial indemnity basis. So you have to pay your lawyer, plus you have to pay the full cost of the other side. That's substantial indemnity. And that's really a punishment to slam that person who wasted so much resources and clogged up the court with a case where some other case had to wait in the queue because this case was wasting a lawyer's time and wasting the court time. So that's another reason for rejecting the case. A good reason a lawyer may reject a case or cannot take cases is the lawyer calendar is full. Some lawyers tend to overwork or they take more cases than they can handle. Those lawyers are heading for trouble. But most lawyers who are reasonable, who are practicable, and who want to properly manage their own caseload would know when to say, well, I cannot take this case. I do not have the time to do this case. And, I don't want the client to languish. Unless the client really, really have a relationship with the lawyer, then you take the case. But otherwise, if it's some person that you have no relationship with, it's good to have the case be dealt with by someone whose calendar is not as full as yours and could devote the attention that case deserves. One of the biggest reasons, and it happens to me too, I'm a cool guy, but of course I'm part of the system. I'm trained in a system, and I'm trained to think a certain way, and I do. Even though I think outside the box, I also screen potential clients for difficult clients. And in most cases, I refuse. I do not accept difficult clients because difficult clients, particularly those clients who have frequently changed lawyers for no good reason, could be a drain on the lawyer's time, the lawyer's emotional and financial resources. Because those are the same clients who sort of suck your time up, and not only suck your time up, but if they're never satisfied, so they're always filing law society complaints against lawyers, or they're trying to sue the lawyers so they could get some money from the insurance, the lawyer's insurance, and so on and so forth. So we have people like that who are just, they fall within the people who file claims that could be frivolous and vexatious and abuse of process and a waste of private resources. But they're difficult. They're also difficult people to deal with. And so it's good at the inception when you come across people who cannot stick with a lawyer, who don't have loyalty to others. Because lawyer and client is a relationship of reciprocal relationship of loyalty. The lawyer has to be loyal to the client and have to have full trust and confidence in the client, and the reverse. The client has to have full trust and confidence in the lawyer and have to be loyal to that lawyer. Not because the lawyer lost a motion, you can get all upset And of course, the lawyer out want to fire the lawyer, want to fight the lawyer, want to complain against the lawyer, want to sue the lawyer. In litigation, and lawyers need to tell clients that if there are two people litigating, more often than not, there's a 50% chance you'll win or a 50% chance you will lose. That's how the cookie crumbles. It's a coin toss sometimes. It depends on who your judge is. It depends how the facts align itself. It depends how the law aligns itself. It depends on the orientation of the parties, the orientation of the counsels, any number of things. A losing case could turn into a winning case because of the lawyer who is involved. So there's a number of factors involved there, right? Or the lawyers simply have no interest in having his or her time consumed by incredible conspiracy theories that have no basis in fact or reality, right? And I've dealt with cases like that when I first started practicing law. To get me to deal with a case like that in 2017 would mean that I slipped. I wouldn't do those cases anymore. A typical example of such a case is a case reported at 2011 HRTO 1582. And it's Hamilton versus, or Patterson versus Hamilton Health Sciences Center. And this is what the tribunal said in this case and dismissed it. At paragraph 259, it said, in this specific case, in my view, there is ample evidence before me to indicate that the applicant's psychiatric condition had an impact upon her perception of the workplace events around her. And then it cited a few of the examples, including the applicant belief without any evidence that strange emails were sent to her that referred to her workplace and home conversations, or her belief without any evidence that her home was being surveilled by HHS, or her belief in the absence of evidence that a former employer was sharing information with HHS with a view to letting HHS know how to pull her strings or annoy or antagonize her. And the tribunal looked at those allegations, and they said, for these reasons set out above, I find the applicant's evidence to be unreliable, such that I'm not prepared to base any findings in this matter solely on her evidence alone. So when I find clients coming to me with these incredible conspiracy theories about people trying to talk to them through their television, or when they see ads popping up on Facebook or something, people saying that people are spying on them because they may speak about the Hilton Hotel, and a Hilton Hotel ad shows up on your Facebook. That ad would show up if you use Google or any other search engine, or even if you use Gmail. As long as you're using technology now, and there are cookies that embed itself in your computer, then ads will be generated based on those cookies. But sometimes people become very paranoid, and sometimes that paranoia is a psychiatric illness. And so I no longer take cases of that nature. It's a complete waste of time, because in the end you're going to lose. And you're going to lose. Whether the client have money or not, you're going to lose. Because when the client loses, the client is going to blame you, and it's a whole bunch of aggravation. So it doesn't make sense. Sometimes there are potential clients who hire lawyers to facilitate illegal or criminal activities. A good example would be real estate fraud. That's a great example of lawyers being hired, and sometimes they're they understand that they're being duped, and yet they fall into those traps. So I don't take any case where I think the client is hiring me to facilitate an illegal activity. And finally, a lawyer should refuse to accept new cases where the lawyer is burnt out. Some lawyers tend to work themselves into the ground. They tend to suffer all kind of illnesses, or they tend to malpractice themselves because they don't know how to say no. I'm not going to accept any new clients until I get a full handle on my caseload. And there was a very, very good immigration lawyer that I did cases against at the refugee board. His name is Ricardo Max Aguirre. And he has a whole bunch of cases reported. But what had happened was Ricardo became overworked. And Ricardo had family issues as well. So the combination of being overworked, having family issues, and not having enough staff caused Ricardo to do a whole bunch of stuff that he shouldn't have been doing. And in the end, Ricardo's license was revoked. Ricardo was kicked out of the profession. He's going to be 48 years this year. But Ricardo had a very good, he was trained at a very good lawyers. He was trained at Waldman and Associates. And there's some very good cases with Lauren Waldman. So Ricardo shouldn't have been in a position where his law license was at risk, but he was. And so Ricardo was disbarred. So this conversation really was prompted by bullet point number 8 in my written list that accompanies this live broadcast. Because a potential client who thinks that people are talking to him through his television, harassing him through his television, and a whole bunch of conspiracy theories tried to hire me. And I said no. And since I said no, he kept harassing me every day for reasons. And I just decided I'm not responding to it. But then, in not responding to it, because who knows, you respond to it, he mightn't like your answer. And it might create more problems. So instead of that, I just decided I'm going to make a YouTube video and tell people how I sort of look at these cases. I think it's important for people to know how I think about these cases and why I might not be interested in a case. I might not be interested in a case because it doesn't fall within my practice area. It doesn't fall within my philosophy of litigation. So, you may come to me to do a human rights matter, and you may say, well, I want you to represent a defendant in a racial profiling case. Well, Selwyn Peters is somebody who is an established human rights lawyer who defends complainants or represents complainants who've experienced racial profiling. For me to defend someone who is accused of racial profiling would be really, really strange. Would be a really, really strange encounter. So To be quite frank, it's not something that I would do. I wouldn't defend someone who is accused of racial profiling. I wouldn't defend someone who's accused of child abuse or child neglect. Right? I love children too much to defend someone in those circumstances. But, you know, my biases, I put them out there so that people know what my biases are. Like a lot of people hide their biases. I do not hide mine. I put it out there so that people know the type of lawyer that they're getting. When you get me as a lawyer, it's somebody that you get all in. I totally devote myself to my clients and their cases. I play to win. And I like the clients who are very strong on their cases. So they say, I'm litigating this for this reason, win, lose, or draw. Right? They know that they have a strong case, but they also know that there are forces out there in the litigation realm that could be against them, that cause the case to be lost. Any number of the unknowns in litigation that pops up. And so if a client realistically controls for that, that's a great client to represent in litigation. Anyway, I thought I'd set out 10 reasons why a lawyer may refuse to take a client. I also cited some case law as well that deals with some of the issues attendant with refusing to take a client. And I'm going to post this on YouTube as well so that people understand, because sometimes people do not understand why a lawyer may not take a case. A lawyer cannot take a case. A lawyer cannot refuse to take a case in a manner that violates a person's human rights. So you can't refuse to take a case because a person is a woman, or a person is transgendered, or a person is black, or a person is Jewish, or any of those factors. Lawyers are governed by the Human Rights Code, and lawyers' practices have to be consistent and compliant with the Human Rights Code. So as long as the rejection of the retainer is for non-discriminatory reasons, the lawyer can refuse to take the case. And even if the lawyer takes the case, the lawyer could terminate the retainer in certain circumstances. And those circumstances include if you do not pay the lawyer as agreed. So if you sign an agreement with a lawyer and say, well, I'm going to pay you $500 a week, and you don't pay the lawyer that $500 a week for about a month or 2 months, the lawyer can terminate the retainer. If you misrepresent material facts or fail to disclose important facts, the lawyer could terminate the retainer. I had that recently where a client completely failed to disclose very, very important facts to me and disclose them on the eve of a trial. That was so not cool. I don't know who the client think you're not hurting your lawyer if you don't disclose important facts. You're hurting yourself. You're hurting yourself, because when you disclose those facts at the last minute, the lawyer loses trust in whatever you tell them, him or her, and the lawyer has the right to withdraw from that case. Now, if a lawyer asks you to cooperate and to respond to a reasonable request, if you don't respond to that request, the lawyer can terminate the retainer. If you ask the lawyer to do something unethical or illegal, the lawyer can terminate that retainer. A good example is some criminal clients. Sometimes you go to the jail to visit the clients, and sometimes the clients want you to bring stuff in for them when you come into the jail, because the jails let the lawyers in directly into a private room. You can't do that. That's something that's illegal. That's a breach of trust. It gives you good reason to terminate that retainer, because that client that sits in that dirty cell at whatever jail it is, they didn't pay for your law license or how you get to being a lawyer. So they could never be worth it. They could never be worth you doing something illegal or unethical. I don't do anything unethical for clients. I don't lie for clients. I don't do any of that stuff for clients. Because at the end of the day, it's me, and the client is gone. So don't do anything unethical or illegal for clients. Or finally, the client did not pay the lawyer's bill on time without making other arrangements for payment. A lot of clients do that. I find that even in my practice, clients would come, and as soon as you slip, they don't pay. So you might do a case, and you might get caught up in the case. And as soon as you win the case for them and you send them the bill, it's hell. You got to chase them down. And so what I do now is, before I do the case, before I do the substantive litigation on the case, the client have to pay. Because I have no interest in chasing that client down. As a matter of fact, more time I just write off the amount owing, because I don't have time to be chasing behind a client for my money. I just count it as my own stupidity in not having the client pay upfront, and it just makes it bad for the next person that come to me with some sad story. You know, I just become hard to people like that. You know, you got a sad story about money, I could give you 10 sad stories about money. So, you know, you want to play, you pay. You know, so I have the play to pay thing with those clients that think they could do a fast one on lawyers and not pay their fees. You know, if I ask you for my fees and you don't pay it within a reasonable time, I just write you and give you another time to pay it. And if you don't, I terminate the retainer. That's how it is. We got to live too. How you think we get these offices? How you think we pay our insurance or our licensing fee? You know, money don't drop out of the sky for us. We're providing clients with a service. And when we provide you with a service based on our expertise, our expectation is that you pay and pay in a reasonable time. So that is what I have to say. Of course, when a lawyer bills a client, the client can have the bill assessed on the Solicitors Act within 30 days from receipt of the lawyer's bills. But I think it was important for me to do this video to explain to clients why a lawyer may not take a case, or the expectations that a lawyer have when the client retains the lawyer, and reasons that the lawyer may terminate a retainer during the life of the litigation. So thank you and have a good night.